it's all about.
Court rise. Appeal in the matter of Tesco Stores Ltd and Lidl Great Britain Ltd and Arnold.
Yes, Mr. Callaghan.
Good morning, my lords. Having considered the transcript overnight, I want to begin by coming back briefly to a point raised by my lord, Lord Justice Arnold. And to that end, could we start, please, in the supplemental A bundle, tab 4, Mr. Unterhalter's second statement. If you could turn forward, please, to page 75.
Sorry, hang on. Supplemental bundle.
Sup A,
Yeah.
tab 4, 75. Page 75 of the bundle. So at the bottom there, we had looked at paragraph 19, which describes the three different logos, and which over the page dated the creation of the stage 3 logo to November 1987. Then paragraph 20 describes some of the researches about the dates of the stage 3 logo, which puts the first use at late 1980s, early 1990s. Then paragraph 21 deals with authorship and says this: Mr. Sander did not know of any way of finding out who exactly created each of the logos. So even Mr. Unterhalter is addressing them as three distinct logos. He's not saying there was a development of a single design in stages. That would be unrealistic when the development occurred over 20 years and where each logo was deployed commercially in turn. These were discrete pieces of work. Then we come to the question of who created them. He believed that it would likely have been employees of Lidl Stiftung who created them. Likely to be employees plural. There is here no assertion that the logos were created by the same person or people. On the contrary, this tends to suggest that they were created by different people, which is what one might expect given the passage of time. You can put that away and we'll see how that evidence is reflected in the pleaded case, which is in core bundle A behind tab 2. And if you could turn forward, please, sorry, tab 1. Turn forward, please, to page 25 of the bundle. The copyright pleading begins in paragraph 29. It introduces two copyright works, the wordless work and the work with text. Work with text is effectively the mark with text. You don't need to worry about the wordless work because the judge didn't address that and there's no respondent's notice about it. Then at the top of page 26, 26b, to the best of the claimant's knowledge and understanding, the works were created in or around 1987. When that is read in conjunction with Mr. Unterhalter's evidence, it's clear that only the work done in 1987, only the stage 3 work is being relied upon. The case does not rely upon the work that Mr. Unterhalter says was done around the beginning of the 1980s, that is to say, the addition of the yellow circle and or the red ring. This is not pleaded as being a continuing development which began at any earlier date.
And the work done in 1987, you say, is the addition of the blue square.
Precisely, my lord. Precisely. And this pleading properly reflects the legal position, because unless this work was all done by the same person, which has never been asserted or pleaded, the only way the work of different people could be accumulated in a single work, that is to say, as if the uniting stages in 2 and 3, would be as if this was a work of joint authorship. It cannot be a work of joint authorship, because Section 10 of the 1988 Act sets out 2 requirements, neither of which is satisfied. First, there must be a collaboration, and second, the contributions of each author must be distinct. Now, a combined Stage 3 and 2 logo fails both tests. The blue square is a distinct addition, and there was no collaboration. And the point was made expressly by Lord Justice Floyd, giving the judgment of the court in the Martin and Cogan case. I have it to hand up if you want to see it. The quote is fairly straightforward, and he said this: "A collaborative work is different from a derivative work. If an author takes as his or her starting point the work of another and decides to adapt, embellish, or improve on it, the result may attract copyright, but it will not be a work of joint authorship. The second author may be entitled to copyright in the resultant work, but it will be a work of sole authorship, the originality of which could only lie in the contribution made by the second author." We say that's precisely the position here. The second author contributes the blue square. That is the only matter which falls for consideration in relation to subsistence. And that brings me to L.A. Gear, which...
Can I just ask you this question? I perfectly understand your argument that you're advancing, but I just want to see how far you push it. Do you say that because the only pleaded work is Stage 3 and the only contribution at Stage 3 is the addition of the blue square, that the court is therefore required to proceed as if all the other elements of the resulting logo are in the public domain?
Well, you don't have to proceed on the basis that they're in the public domain, but you do have to proceed on the basis they are irrelevant to the claim that's being advanced, because no pleading is advanced which relies on the conception of the yellow circle, nor could there be one. So I accept that on the materials before the court, if there were a Stage 2 logo copyright work, it appears to be owned by Lidl. I don't say it's in the public domain, or that I don't even say, because I don't have to, that there's no copyright in it. What I do say is it's of no relevance to the cause of action that's being asserted.
So, do I understand from that it is your submission that the finding of copying of the yellow circle, which as I understand it you don't dispute, is legally irrelevant?
Yes.
Thank you.
It's irrelevant to, in particular, to infringement. So let me just slightly qualify that. It was open to the judge to say, well, I can see other indicia of copying here, and as a matter of logic, that helps me decide on derivation. But when it comes to substantial part, which I do challenge, it wasn't open to the judge to say, well, you've taken the yellow circle, and therefore that helps Lidl's case on substantial part.
Understood.
The last point I wanted to just cover off was L.A. Gear, which my Lord Justice Arnold mentioned yesterday. This case is held in high esteem in my corner of Gray's Inn because Lord Justice North described the relevant submission advanced by my learned friend Mr. Purvis as novel and disturbing. The submission was that copyright in a work might be impugned by the fact that it was itself derived from earlier drafts by the same author. And what Lord Justice North said was this: what the Copyright Acts require is that the work should be the original work of its author. If in the course of producing a finished drawing, the author produces one or more preliminary versions, the finished product does not cease to be his original work, simply because he adapts it with minor variations, or even if he simply copies it from an earlier version. My lords, that is obviously right, but it has no bearing here. This is not a case of preliminary sketches in the course of producing a finished drawing, and the work is not said to have been done by the same author. Lord Justice North was dealing with a continuum of contributions by a single author to a single work, and as we will see shortly, that position is expressly denied by my learned friends in their argument for Lidl. So, going back to the judgment where we were yesterday, we had been through the judge's reasons for rejecting our case on this issue. And we see some confirmation to the analysis I've just been through and the basis upon which Lidl seek to defend the judgment. They do not rely on the work of any other authors in the early 1980s. If you could take core bundle B and turn forward to tab 26, where you'll find the responsive skeleton. And page 544, please. Picking it up in the second line, the assumption in Tesco's argument is that the mark with text...
Sorry, which paragraph?
I'm sorry, paragraph 64.
64, yeah.
Second line.
Yes.
The assumption in Tesco's argument is that the mark with text was an iteration of one logo that was continuously developed. That was not the evidence. To be clear, that's not our argument either. Our argument is that stage 2 was the starting point for stage 3 in a discrete development. And then further down the page, Tesco suggests that the presence of a yellow circle in another work means that the presence of the yellow circle in the mark with text involves no creativity at all. That is obvious nonsense. It is itself a creative decision to incorporate into the new work aspects of an older work, including which parts to include, which to keep, which to change, or not to change. My lords, that is a gloss on what happened here. So far as material, the whole of the stage 2 work has been kept without any change whatsoever. Moreover, we do not understand this to be part of the judge's reasoning. But in any event, the argument is bad on the law and on the facts. First, as a matter of law, if an author chooses to start not from a blank canvas, but from a single prior work, that choice cannot be creative for subsistence purposes.
Why not?
Just starting with the whole of someone else's work.
Rather than a blank canvas. Why is that not a creative choice in itself?
Because all you've done is copy. You have originated nothing at that point. You can then do some creative work, but you can't take someone else's work, put it in front of you and say, I've already created something. You haven't. You've done the opposite of creating something.
No. It's not the copying. It's the decision to juxtapose the old with the new.
Right. Once you move away from the old, you can be said to create something, but just by choosing it. So at this stage, there is no juxtaposition. Just by selecting someone else's work, all you've done is taking their creative decisions, their skill and labour. All I did before I added the blue square to Caravaggio was copy.
And you say it would have made no difference if you'd chosen Gainsborough rather than Caravaggio?
Made no difference at all. Made no difference if I chose the stage 2 Lidl logo. I haven't done anything yet. As a matter of law, I have originated nothing. It might be possible to select multiple pre-existing works for the purposes of combination or collage, and thereby exercise creative choices. But if only one work is chosen, there are 0 creative decisions, no originating activity. The starting point is a slavish copy. And that is the effect of this court's judgment in Martin and Cogan. And that is why copyright can only subsist in the departure from what was there before. It's also the reasoning in Dix and Brooks.
I don't have, my lord's, familiarity with all the copyright cases, and I think you said you had, Martin.
Yes, so I have copies of, so I refer you to L.A. Gear and Martin and Cogan, and I have copies here. Apologise that they're not in the bundles, but as you'll see on our understanding of the case, this isn't a point that's being taken against us, but I fully understand that it may help to interpret our argument.
Are they stapled or hole punched?
They are hole punched and with pig tips. So, my lords, that's as a matter of law. We say no origination. What about on the facts of this case? One could conceive of a position where there was a huge amount of research done to find a starting point to be slavishly copied. My position is still no creativity, but at least on the facts you might have some labour to refer to. But here, the starting point for the Stage 3 logo was staring the author in the face. They didn't search high and low for their choice. It was probably part of their design brief. There's certainly no evidence that there was any sort of creative selection procedure by the author whatsoever. So the Stage 3 author did not originate any part of the Stage 2 work and did not make any creative choice in choosing to copy it. If I could return then to the judgment. Paragraph 288. So this is core bundle B, tab 28. Paragraph 288 is on page 647. And towards the middle of that paragraph, the judge gives her second reason for rejecting our argument on the nature of the Stage 3 right. 6 lines down. My second reason is because simplicity of design and or a low level of artistic quality does not preclude originality. With respect, that is not an answer to the argument. That is answering a different question. What is the threshold for copyright subsistence? As to that question, the judge continues in this paragraph to refer to two cases decided in relation to the old skill and labour test, Caro Step and IPC magazines and NGN, and she distinguishes a third case, Solar Thompson Engineering and Barton. This approach is also problematic. In my learned friend's responsive skeleton, they say that although the judge uses the word skill and labour, it's clear from context that she was applying the new EU test.
Well, given what she says at 282 and 283, which seems to have been common ground.
Right. But that defence of this paragraph doesn't work as a matter of logic, because the judge was trying to work out where the threshold lay for copyright subsistence. And at my learned friend's urging, she relied on old skill and labour cases. Now, it's common ground that the new EU approach...
Well, forgive me for interrupting,
yes.
But is she wrong in saying that you relied on Solar Thompson?
I'll explain why it's okay for me to do that. It's not okay for my learned friend to do that.
They're both applying the common law test. They're, on your argument, both equally irrelevant.
No, they're not. Let me explain why. It's common ground that the new test imposes a higher threshold, intellectual creativity. That's my learned friend skeleton, paragraph 60. That means that if a work failed the old test, it would also fail the new test. So it made sense as a matter of logic for us to rely on Solar Thompson engineering, because we said the blue square would even fail the old test. But the converse argument is not sound. If a work passes the old test, it does not follow that it would pass the new one. So the judge was wrong to rely on Caro's step for the proposition that simplicity of design did not preclude copyright subsistence. Because if that simplicity did not comprise an intellectual creation, then there would be no copyright. So there isn't a perfect symmetry here in the position.
So just looking again at paragraph 288, I think, well, let me ask you, do you accept that the act of bringing together the little text with the yellow circle and the blue background could attract copyright protection, but only in relation to the addition of the blue background?
It's not a straightforward question to answer, because I don't accept that that was the act. What I accept happened was there's a pre-existing work, a blue square has been added to it, and I don't accept that the addition of that blue square attracts copyright protection. Right. I don't really understand what's meant by the act of bringing together, because it seems to be rather overselling what happened. There wasn't some creative combination, there was a mere act of framing something that was already there. My lords, the third error that we rely upon is an evidential one. The burden of proving that the design of the Stage 3 logo involved intellectual creativity fell on Lidl, as my Lord Justice Arnold has indicated in THJ paragraph 24. They could quite properly point to the logo itself, but that doesn't really help them because it's just a blue square. They could also point to the efforts which were in fact involved in creating the Stage 3 logo. And one thinks of the Standard Oil argument in the Exxon case. We spent lots of time and money working out a new word, Exxon, as our trademark, so we should get a copyright. But as we've seen, Lidl had no evidence of those efforts. So if you turn to paragraph 289 of the judgment, the judge says this: someone in the employ of Lidl took the Lidl text and the yellow circle with the red border and superimposed them on a blue background to create the mark with text. On balance, I consider that this is likely to have involved time, labour and creative freedom, even if the artistic quality is not high. Well, the artistic quality is irrelevant, and the judge needed support for her conclusion that this exercise involved significant creative choices by the author. I mean, one possible development story involves a board meeting where someone says, we need a logo that will work on a flag, and someone else says, let's just add a square blue background to what we already have. The logo itself does not speak to a more extensive development process. And in the absence of any evidence from Lidl, the judge relied on evidence from Tesco. She says in this same paragraph, Tesco's own evidence as to the various combinations of apparently basic shapes and colours considered by its own designers in arriving at a decision as to the CCP signs tends, in my judgment, to bear this out. That seems to be the critical supportive reasoning, perhaps the only supportive reasoning, and we simply do not understand how that can assist as a matter of logic. If one considers the Painter case that I took you to yesterday, if those portrait photos had instead been taken in a photo booth where most of the choices were nothing to do with the author, background, lighting, framing, angle of view, development, and the author simply told the subject to sit and put their money in, the subsistence analysis would be very different. And the court could not say, well, Diane Arbus or Annie Leibowitz take great care with their portrait compositions, so copyright must subsist in the photo booth photographs. The facts applicable to one act of creation cannot be assumed to apply to another. But we also say that even if it could be relevant, the Tesco evidence which the judge had in mind did not support Lidl's case. Indeed, if anything, it provided a further indication that the judge rather got her bearings wrong on the subsistence issue. If you could take, please, Supplemental Bundle A and turn forward to tab 19. This is a signage exploration document put together by Wolf Ollins, one of Tesco's external design agencies, and it dates from July 2019. And the judge refers to it in her paragraph 308, Roman 13, as part of the copying story. And if you turn forward to page 251, you see a series of draft price signifiers. Now, the only change between the images on the top row is that the square frame colour has changed from red to black to blue. It seems that the judge had in mind that the work shown on this page resulted in perhaps 6 different copyright works. Well, if that's right, we say it's plainly wrong. Changing one of these designs to another is the work of moments. A single keystroke can do it. And the colours on the left-hand side have then been reversed in the second row. This sort of contribution does not, we say, give rise to protection liable to last over 100 years. Turn forward to page 253. Again, variations on a similar theme. And 255. There are about 100 different designs in this document alone, and we do not for a moment accept that they are each independent copyright works. And even if you take them in categories, so back on 251, you consider those all to be variations of one work, then the decisions involved, the creative decisions involved, are very much more extensive.
So, can I just ask you, it follows from what you've just submitted that your clients would be entirely content with people copying these? Because on your case, there's no copyright in these, and therefore they're not protectable by Tesco, and therefore any of their competitors can copy these.
So that's not quite what I said. What I said is there aren't 100 different copyright works here.
Right.
Right.
So is there one copyright work, and if so, which?
Right. So we don't know, because we don't know what the first one was. I don't necessarily accept that the original version of whatever has been varied here attracted no copyright protection, because we haven't investigated who did what in this regard. As the judge pointed out, we didn't have that evidence. But it's going to be close to the line. But the point I was about to make is that even these involve many more creative choices than just the addition of a blue square background. There are 3 different shapes. There's a circle and 2 squares. There are 2 different shape colours. There are relative positions of the shapes, relative positions of the text, the fonts for the text, the colours for the text elements. So there are 10, 12, 15 decisions that are being taken here, as against a couple. And further still, as I said, the judge received no evidence about how these were produced. They could have been based entirely on templates in the software package that's being used, in which case, almost certainly no copyright. Certainly no copyright owned by the designers. So for these reasons, we say the judge made a sequence of errors in relation to subsistence, and if she had correctly identified the contribution of the stage 3 author, she would have held it to be the addition of a blue square background, which was not enough to result in copyright protection.
Can I just ask this question? If you look at paragraph 290, in the penultimate sentence, the judge says this: ultimately, the litmus test must be whether the mark with text involves the exercise of intellectual creation involving the expression of free creative choice. Do you accept that that's applying the correct legal test?
That is applying the correct legal test, but critically, the context had to be as against the stage 2 logo, whereas the judge has subsumed the prior work in stage 2 into her analysis, as I showed you yesterday by the repeated reference to yellow, to multiple colours, multiple shapes, and indeed to text.
So you say, is this right? It's the right test, but it's applied to the wrong thing.
Yes.
The judge is applying it to the mark with text in that sentence.
Right.
And you say that that's the error. She's got the right test, but she's not testing the right thing.
She has in effect tested the work that started in the 1970s and ended in 1987. And she needed to test the work that took place exclusively in 1987. That was the pleaded work, and as I've explained in law, there was no basis to unite the labours of the earlier authors.
Yeah.
My lords, we can move on to infringement, and we have two grounds of appeal here. The first is very short. The judge purported to follow the guidance of Lord Millett in Designers Guild, and that was embedded in the quote under paragraph 294 of the judgment. The first step is described towards the bottom of the page. It is a visual comparison of the two designs, noting the similarities and differences. And we're told that at this stage, similarities may be disregarded because they are commonplace, unoriginal, or consist of general ideas. And we say if one carries out that comparison, the similarity here is a blue square, it is commonplace, unoriginal, and consists of a general idea, and therefore, taking the route that the judge purported to take, there should be no shifting of the evidential burden, and that should have been an end of the matter. Now, at first blush, this argument might seem rather defensive, particularly in circumstances where the judge made a finding of copying. But if one takes a moment to consider the question to which the judge was properly seeking an answer in evidence, we say it takes on a rather different complexion. That question, which was to be directed to professional designers at Wolff Olins, was, where did you get the idea for a blue square?
Sorry, I thought you weren't challenging the finding of copying.
We're not challenging the finding of copying, we're challenging the judge's approach to substantial part.
Understood, yes. So you say she's wrong on substantial part because what's been taken is not original. That I understand.
Yes.
But
well,
you just said that she was wrong to find a shifting of the evidential burden, but that's about copying, isn't it?
Well, I can see what I'm really saying is that in following a Designers Guild, the judge ought not to have engaged with the question of copying. I don't say having engaged with it, she came to a decision that wasn't open to her on the materials before the court.
I'm sorry, I'm a bit lost.
That may be something akin to
We're considering the question of infringement.
Yes.
On the assumption that there is copyright protection for the stage 3 logo,
Yes.
which on your argument consists of the addition of the blue square.
Yes.
If the blue square has been copied, which perhaps a judge found that it had, then you've taken all of it, not just a substantial part of it. Thank you.
Right. I will come to address that point. If the blue square has been copied, I will explain that we've taken the idea of it, and that idea cannot amount to what is required in law, which is the author's own intellectual creation. Right. So it's no post-info pack. One no longer looks at how much has been taken and compares it with the state of the original work. One looks at what's been taken and says, does that measure up? Is it enough? Are there enough creative decisions that you have purloined?
Mr. Culligan, is the point you're trying to make that the judge didn't ask the question, did you copy the blue square? She asked the question, did you copy the mark with text? Is that the point you're making?
That's certainly part of it. But what she has missed out entirely is the question, is the stage of, are the similarities commonplace, unoriginal, or general ideas? And there is the point I'm making is there's a utility to that filter. Because it's not, we say, sensible to ask a professional designer, where did you come up with the idea for a blue square? Because the implied premise in that question is that a professional designer might struggle to come up with a blue square without prompting. And that premise is not realistic. And even if you include the yellow circle, it makes no difference because the resulting combination appears all over the world on every sunny day.
Yeah, but I'm puzzled as to the point you're making. I mean, I fully get, you say that what's been copied is wholly unoriginal, therefore no infringement. That's a very clear argument. But you started this part of your submissions by focusing upon what Lord Millett is saying. As he makes clear, he's describing a structure for deciding whether or not there has been copying. But you don't challenge the finding of copying.
Well,
so I don't understand what separate point you're trying to make. As I say, I fully get that you're saying nothing original has been copied.
Yeah.
That's different.
So look, I can see that there is a tension between saying we don't challenge copying and saying we don't think the judge should have engaged with copying. This is a short ground of appeal, and I'm not going to spend any more time on it. If you think it's not open to me, that's fine. The point is simply that we think the better approach in following Designers Guild is that when you've only got a blue square in common, that really should be the end of the analysis. I'll move on to the last ground of appeal, which relates to substantial part. My learned friends appear to consider that we are challenging copying here, but we're not. Even if there was copying, the judge still had to answer the question, what was taken? And in particular, was it sufficient to amount to the intellectual creation of the stage 3 author? The argument here is obviously related to our submissions on subsistence, but it is stronger, we say, for two reasons. First, because not everything which weighs in Lidl's favour on subsistence was taken on any view by Wolff-Olins. That much is common ground. And second, because it is clear that Wolff-Olins needed no assistance with expressing the resulting image. So all they could have taken was the idea for the image. And I'll take those two reasons in turn. First, not everything was taken. So at this stage of the analysis, we have our stage 3 work, and this court will decide what elements are properly to be included in that work. But there are two elements which cannot have been taken. First, the shade of blue. That's relied on in paragraph 62 of my learned friend's skeleton. They say there is creativity in the adoption of that shade of blue as opposed to another shade of blue. Well, let it be so. But the shade of blue in the mark with text was never said to be copied. Tesco had been using blue for decades, and the particular shade of blue in the CCP signs had become one of their 3 primary branding colours in 2016, and that was unchallenged. That's McKettrick, paragraph 49. So that cannot weigh in Lidl's benefit. Second...
So Tesco have been using blue in that particular Pantone shade?
Yes, since before any of the alleged copying started.
2016.
2016. Second, the size ratio of the square and the circle. Paragraph 63 of my learned friend's skeleton. They say, does the circle have a diameter equal to or greater or less than the width of the square? In what ratio? So they're relying on the particular ratio between circle width and square width and height. But the ratio is different between the mark with text and the CCP signs. You have to keep in mind that the underlying idea in both cases is that the square is a background framing device. It's not the main event. But if, in that context, you look at the first page of the judgment, I still have it, Core Bundle B, tab 28, page 561. Under paragraph 2, you see the mark with text. The blue square is perilously thin at the top, bottom and sides, almost entirely occluded by the red ring. And then turn to the second page. Well, the sign under paragraph 7 is confected. That's not actually what was used. Look at the example of the sign. And then there's another example above paragraph 10. There's a lot of variation. Sometimes there's a bit more blue showing. Sometimes the whole sign is abbreviated so that the yellow circle is taller than the blue frame. This is not an integer of the work that is reflected, reproduced by Tesco. So that's my first point, why the argument is even weaker on infringement. And we really don't want to be in a situation where the big club card prices is not an infringement, but it is an infringement if you happen to reproduce the ratio. We really would be through the looking glass there. The second reason was that Wolf Ollins needed no assistance with the resulting image. There is another constraint on what it was that Wolf Ollins derived from Lidl, and that is found in what they had already previously designed. If you could take, please, Supplemental Bundle A and turn forward to tab 17. This is an exploratory document prepared by Wolf Ollins in July 2016. So that is before the copying started. The judge held that the instructions from Tesco which led Wolf Ollins to consider the mark with text were given in December 2016. And that's paragraph 308, Roman 3 of the judgment. If you turn forward, please, to page 243. So towards the middle top of the page, you'll see that Wolf Ollins independently designed a yellow circle containing text centrally disposed within a blue rectangle. Now, it is not our case that that was the starting point for Wolf Ollins' work on the CCP signs. That's the point that Lidl have addressed in their responsive skeleton. Our point is rather more subtle than that. It is that Wolf Ollins had already expressed the key element of the CCP signs, a yellow circle centrally disposed within a blue rectangle, and they'd done so quite independently of Lidl.
Is there evidence that it was the same person involved?
No. So when they came to introduce elements of the mark with text into the CCP signs, as the judge held them to do, they didn't need help with the expression of those elements.
Well, I'm a bit puzzled in the light of the absence of evidence. So just to consider it hypothetically this way, you've already accepted that this one was not the starting point for the CCP signs. Just assume, for the sake of argument, that this one was designer A, who shortly after executing this design left Wolf Ollins' employ. Okay? And then the person who does the work on the CCP signs is the designer B, who's been employed by Wolf Ollins subsequently. So On that hypothesis, what's the relevance of it?
So, the argument assumes that as between July July 2016 and December 2016, there is a degree of continuity in Wolf Ollins and the Wolf Ollins work for Tesco. That means when in December 2016 someone wants to mock up a sign with a yellow circle and a blue rectangular background, it is that is something that the group knows how to do.
Well, that might be highly relevant to the question of copying, because I could understand that on that hypothesis one might say, well, the obvious explanation for the similarities is not copying,
Yes.
but that they started from this.
Yes.
But that's not the judge's finding.
No, because I didn't have any evidence from Wolf Ollins. So what I say, so I am obviously slightly constrained in relation to what I can say about origins, but what this does show is that Wolf Ollins had the independent ability, when working for Tesco, to create something that was very, very similar.
I mean, what you were really doing is asking the judge to infer that there was a collective corporate memory of what they'd done.
Amongst Wolf Ollins? Well, the position at trial was that it goes back to the question of burden. There is a fundamental difficulty with asking someone, where did you come up with the idea for a yellow circle? And that difficulty is reflected when going back to witnesses and saying, where did the idea for a yellow circle come from? And the way that played out at trial was, we didn't have a witness who said, I had the idea for a yellow circle, or I had the idea for a blue square. So we are where we are in relation to that. But we say, I mean, you can explain that by conspiracy if you like, but we suggest it's quite understandable given the simplicity of these designs. But I'm constrained by the evidence and the factual findings of the judge. Notwithstanding those findings, I say, look, this was in effect a design that the same designers, the same Wolf Ollins, that is to say, I can't say the same individual, but the same design agency working for Tesco several months before had already basically conceived.
Right, so there's another way to put the argument, which is nothing to do with the fact that it's Wolf Ollins both times, which is just, this is evidence, you say, of the low level of creativity involved. This is not a startlingly novel design.
Indeed. Quite the opposite. And of course, my lord, this is, on my case, more sophisticated than the work with which the court is concerned. Because the work with which the court is concerned doesn't have a yellow circle conceived by the stage 3 author. And in the context to which my Lord Justice Arnold has put to me, and given the facility with which these sorts of simple symbols can be created, one asks the question, what benefit might Wolf Ollins have derived from Lidl? And we say it could only have been the idea of a yellow circle with the square blue background. That's the only answer that really makes sense, because nobody involved in professional design needs help to express that idea. It's utterly facile. You might see it and think, I like that idea, I'm going to use it. You don't see it and think, hold on, I better take a copy and put it next to me whilst I generate my own version of it. It's just not that sort of work. And again, that applies a fortiori if you're only considering the blue square background. So, well, as the judge approached copyright infringement in a two-stage process, you go back to the judgment at paragraph 299, that's the first stage at 299, where she compared the mark with text with the CCP signs, said a visual comparison of the CCP signs with the mark with text indicates that the similarities, the blue background with the yellow circle superimposed on it, are sufficiently close that they're more likely to be the result of copying than mere coincidence. In my judgment, the blue background with the yellow circle plainly forms a substantial part of the mark with text. For reasons I've explained, this assessment is not confined to the correct subject matter. That's the first error. The second error is that the judge has not considered whether what has been taken goes beyond an idea. And when one is dealing with such rudimentary similarities, the distinction between an idea and an expression is important. My lords, I was going to move on then to the injunction, copyright injunction. And our position there is all of a piece with our position on infringement. The judge held that the cost of rebranding to Tesco would be of the order of £7 million. There's no challenge to that figure before this court. So this part of the appeal rests entirely on the proposition that future damages for copyright infringement would be a tiny fraction of that cost. Now, crucially, it's common ground that for present purposes, the value of future damages can be assessed by reference to negotiating damages, and that in turn carries with it three legal principles which are not in dispute. First, the subject of the negotiation is a license under the right infringed and nothing else. Second, the subject of the negotiation is a license to do the act of infringement and not a wider license to the whole right infringed. That proposition is found in the 32 Red case. The trademark was 32 Red. The defendants used the sign 32 Vegas, and the judge, Mr Justice Newey, as he then was, decided the notional license was to use the mark 32 Vegas and not the parent right. The third principle is that, quoting from paragraph 7 of the judge's judgment, the commercial context will include the price of alternative courses of action. In other words, the availability or otherwise of the subject matter of the notional negotiation from an alternative lawful source. Subject to the point about the licenses, the alternative courses not having to be identical, that is correct. The difference between the parties here collapses to a single issue. Can Lidl's asserted reputation elevate the price of a notional copyright license? And we say not, for two reasons. Firstly, because the procedural context for this debate was expressly one in which the trademark infringement and passing off claims failed. And secondly, because any such reputational benefit would be included with alternative lawful sources. That means we're not relying on our first ground of appeal. I'm only taking grounds 2 and 3. There is an overarching point which relates to the subsistence appeal, and that is that one needs to distinguish between Lidl's reputation in the mark with text, the whole thing, and the reputation in the subject of the license in issue. Now, that's either the blue square with the yellow circle or just the blue square. If it's just the blue square, there's no evidence of any reputation. But if it's the blue square with the yellow circle, the reputation is still very much less than the whole mark. You don't have to pay for the right to use the word Lidl in relation to that. But because of the way this is going to develop, and I'm not going to take a long time on it, I need to explain briefly why we're dropping the first round of appeal so you understand where we are. The first ground took a hardline position regarding the exclusion as a matter of law of the brand value of the copyright work in issue. And on reflection, we consider that brand value is in effect something like a convoyed, a good or service. And if I explain that by starting with an analogous patent content. If you consider a notional license to make patented printers, having that license allows the licensee to make profitable sales of printer cartridges. Printer cartridges are not the subject of the patent, but one can see that notional negotiating parties might agree to terms under which elevated royalties were paid on sales of printers because you're going to make money off the cartridges. And if sales of cartridges are a profitable endeavour, which the licensor can control through the parent license, then paying higher royalties makes economic sense. So turning to the facts of this case, if the copyright license that we're concerned with came with a profitable convoyed benefit, which Lidl effectively controlled, that benefit could justify an elevated license fee. And the convoyed benefit could reside in the goodwill associated with the licensed work. So moving forward to the first ground of appeal, the procedural context, the copyright injunction was granted in circumstances where Tesco accepted the judge's findings, properly gave rise to injunctions in trademark infringement and passing off, and it's common ground that those injunctions would prevent commercial use by Tesco of the signs in issue. But our intention was to challenge those findings on appeal, as we now have, and our argument was to the judge was that the copyright claim did not justify an injunction independently if those claims had failed. So that was the basis upon which we invited her to consider the copyright injunction. And our complaint is that she failed to give effect to that contingency, and that it is implicit in her assessment that Lidl had a valuable reputation in the blue square and the yellow circle. Now, in their responsive skeleton, Lidl point out that this particular argument may be sensitive to the basis upon which the trademark and passing off claims appeals succeed, and although that may be unlikely, we accept it as possible. So this is an issue which may best be considered in light of the detail of my Lord's decisions on those appeals. I mean, if they succeed, it seems likely the court will have decided that the use by Tesco of the CCP signs gave rise to no significant price-matching messaging, and therefore no significant reputational advantage to Tesco, for which they then wouldn't have to pay. But as I say, that may be something that makes more sense for you to revisit, having decided what you are to decide. The second ground of appeal, the third in our written documents, is that it relates to alternative lawful sources. In accordance with the 32 Red approach, Tesco needs a license to use a yellow circle with a blue square background, or possibly just a blue square background. And we found some alternative lawful sources of similar designs. My Lords, take the core bundle, bundle C, and turn forward please to tab 33. This is our skeleton arguments on the copyright injunction. And if you turn please to page 687, under paragraph 30, you will see an image that was available free of charge online.
Was that evidence before the judge?
Yes, it was.
Thank you.
Does the judge's order stop you from using these?
Well, this is a point I'll come on to. We can't see how it does, but it demonstrates the futility of the injunction, that it doesn't stop us doing that. And I'm going to develop that argument briefly in a moment. If we assume that that is a copyright work, which it must be according to Lidl's case, because it's more sophisticated than that which Wolf Ollins were found to have taken, then we ask rhetorically, why is it available free of charge? And the only sensible answer is because it's of negligible objective value, that it is trite and commonplace, and that it could be produced independently without significant difficulty or cost. If you turn the page, you'll see another one.
Well, how can one assume that? So take free software, as it's sometimes called, Creative Commons, those kind of things. Works that undoubtedly require a great deal of effort and creativity produce are deliberately made available free of charge because the authors think that it's in the greater good that they should do so.
But very well. My submission is that that's not what's going on here.
How do we know?
But
do we have any evidence from Clip Safari as to why they offer them?
You have no evidence
free of
beyond the price. But you do have a price for the next one. So that is a competing commercial endeavour. The price for the next one, the top of page 688, was $40. Perhaps a tiny bit more sophisticated, although there's not much in it. And then there's a third alternative, we say, which is to simplify and crop one of those images. And you see we've done that under paragraph 32.2. And we say the notional negotiator in Tesco's position.
I don't think it affects your argument in principle. I'm a little puzzled because to my eye, it's not just a cropped version of the image. You've taken out the halo.
Yes, so I said simplify and crop. Simplified by taking out the halo, so rather than a blended sun, it is now a discrete sun, and then it's been cropped.
So that takes you into the cases about copying by a process of alteration to an unobjectionable source, as to which there is case law.
Yeah, absolutely. But yeah, indeed. But I've taken a free image. I've rationalised it so it's just two colours, and then I have taken a part of it. Okay. What I'm saying, my lord, is that this is this would be in the understanding of the notional negotiators. That would be a course that they could take, and that they could use that at zero cost, and that they could use their pre-existing shades of blue and yellow, and that they could add their own wording. Now, the response of Lidl and the judge to this proposition is to say, if Tesco takes one of these licenses, they won't get the reputational benefit. But that's not right. Assume for present purposes that one can get to the 32.2 logo without any conceivable objection. A license to that third image is indistinguishable from the notional license in issue. If it carries with it reputational benefit, so be it, because that reputational benefit is not part of the license in issue. If one considers the patented printer analogy, if a third party comes along and offers a lawfully competing printer license for a knockdown price, the licensee to that license still gets to sell cartridges. The claimant patentee can't say, it's only my license that gets you into the cartridge market, because they cannot control that market independently of their patent license. Similarly here, Lidl cannot control the reputational market if you're only considering the copyright license by that right. The value reputation is not exclusive to Lidl as a copyright owner. And we can see the judge addressed this point in the core bundle, tab 36, page 714. Paragraph 32, she said that these third-party images did not convey the message already conveyed by Lidl's logo. But the license in issue isn't a license to use Lidl's logo, it's a license to use one or two of the elements found within it, and those elements are in all these images. And at the end of paragraph 32, I agree with Lidl that in light of these findings, the design was not fungible and the alternative images on which Tesco now relies cannot be treated as comparables. Equally, the price of £25,000 for a rudimentary design does not appear to me to adequately reflect the true level of Lidl's likely loss or the commercial context I've described above. This reasoning implicitly relies on exclusivity, which cannot be found in the copyright claim. If Tesco can find a legitimate route to a blue square and a yellow circle, then under the law of copyright, they can take whatever benefit that design affords. In other words, these third-party works could lawfully be used to convey the message of value that Lidl complain about.
Isn't this the argument that it's routinely run and routinely loses in all intellectual property damages claims? The infringer always says, well, I could have had a non-infringing alternative. And I thought, I'm going to forget the case now, isn't it Horseshoe Nail that says that's not right?
Right. So it is, United Horseshoe has been expressly distinguished in several cases, one of which is Force India, I think, from my Lord Justice Arnold, in the context of negotiating damages. It's now well established that in relation to negotiating damages, alternative courses of action are relevant. So United Horseshoe is only good law now in relation to General Tyre Category 1, actual loss suffered. And even then it's listing and taking on water. But it is common ground in this...
Nice to know I'm out of date, Mr.
It's common ground in this case that we're concerned with negotiating damages, and therefore it's not an answer.
Just going back to your proposition that reputation is not controlled by copyright. If the judge had found that Wolf Olin / Tesco had come up with the design independently without copying, that would support your point, wouldn't it? Because the design independently produced might carry the same reputational advantage, but would not be protected by copyright.
Precisely so. So let us assume that we had, that Wolf Olins had come up with the design under my paragraph 32.2 independently, and then that had come through. Precisely the same reputational damage would have resulted. We say it wasn't any, but on my learned friend's case, but the copyright claim fails because the copyright cause of action does not protect that reputation per se. It can protect it as a convoyed benefit in circumstances where there's no competing way to get to the sunny uplands of printer cartridges or reputation. But if you can't maintain that exclusivity and the parent right, then the convoyed benefit goes too. And then the final point is the point put to me by my Lord Justice Lewison, that the availability of these images shows the futility of the injunction in issue. The Clip Safari image is not said by Lidl to have been copied from them. That must be right. Anyone in the world is free to take the benefit of Clip Safari's creative choices. I suggest that it is not conceivable that moving from that to paragraph 32.2 could be an infringement of Lidl's rights, and that design could therefore be deployed tomorrow without breaching the judge's general copyright injunction. My lords, unless I can help you further, those are my submissions.
Thank you very much, Mr. Scott. Yes, Mr. Brandon.
My lord, I don't know if it is the practice of this court, to give the transcript writers a break at any point, but
No, it's not.
In that case, my lord, may I begin by acknowledging the somewhat intimidating circumstances in which I find myself. One pupil master in front of me, one pupil master to the left of me, and defending the judgment of the wife of my third pupil master. It is literally an anxiety dream made real, and I hope that your lordships will be gentle with me. But it does have the advantage that all in this court know the authorities both on the substantive law and indeed are in many cases the authors of the authorities on that substantive law, but also those that touch on the role of the appellate court in considering the first instance judgment. And it's not therefore necessary for me to repeat those authorities or the principles within them to feel confident that the court has them well in mind. But it is important, in my submission in this case, to have them well in mind because of the demand that they make on an appellant to identify a clear error of principle when challenging a multifactorial assessment of the kind that is at the heart of the trademark infringement and passing off findings, and indeed the findings in relation to copyright infringement, or in respect of some subsidiary fact that feeds into that multifactorial assessment to show that the finding of fact is rationally insupportable. Now, coming into this hearing, my lords, and based on the appellant's skeleton argument, we understood that the appellant did have an overarching point on principle at the very head of its submissions. And we said in our minds that there were two versions of that principle, one an extreme version and the other a reasonable one. The extreme version is one in which a trademark infringement case should admit of no evidence of consumer reaction, or should only do so in circumstances where it is supported by a survey that accords with the Whitford guidelines, statistically sound and representative of the class of consumers in question. In contrast, the reasonable proposition was that all evidence in a trademark infringement action should be assessed with caution, in particular on the question of whether or not the evidence could be extrapolated out to inform the judge's view of the reaction of that notional legal construct that is the average consumer. And my lords will tell immediately, from the names that I've given them, that we were going to say that the extreme version, the one that we submit, did underlie their skeleton argument, should be rejected. But I believe it would be fair to say, following the questions that my Lord Justice Arnold put to my learned friend yesterday, that that extreme version of principled error is no longer being advanced. What then is said to be the error of principle that justifies this court interfering with what we submit is a careful, considered, and deeply admirable judgment. The two sins that they accuse the judge of are ignoring her own assessment in favour of one driven by the evidential matters that they raise on their appeal, and of failing to appreciate the significance of what I have called the reasonable proposition, namely the caution that should always be exercised in respect of evidence in trade.
Can I just ask you this, Mr. Brandreth? You say that the appellants accuse the judge of ignoring her own assessment.
Yes.
The judge did, I think, carry out an assessment of whether there was sufficient similarity between mark and sign for the sign to call the mark to mind. But did she ever carry out her own assessment of whether what I'll call a price matching message was being conveyed by the sign?
Absolutely she did, my lord. I understood from your questions yesterday to my learned friend that that was a point of particular concern for you. And indeed, I think also that that is why you submitted, or excuse me, one way around of putting it, you questioned whether or not the key finding that the judge made was not the one expressed in respect of the vox populi,
Yes.
the one at 111.5. And in our submission, the answer is it is not the key finding.
Right.
To the contrary, as I will show you, once one understands the context of the debate that happened at trial, she did have a basis for going from the link to the understanding that the kind of damage that would arise was bound to happen. The reason why it is perhaps not discussed more fully is that it was so apparent from the matters that had already been looked at, but which necessarily have not become the subject of discussion in this court, or indeed, in some respects, the subject of discussion in the judgment. Because one of the points we make is that the judgment rightly focuses on what the parties ended up disputing at trial. And the matters that are actually, by the time of the final judgment, were more or less taken as read, can be dealt with, as she does, very shortly, but which themselves, we say, would have justified the conclusion. But I can go further than that, my lord, because I want to show you that I say she does so expressly. Right? She does so expressly in the context of unfair advantage in particular. So, my lords, as I say, the two errors that we understand them now to be saying are what justify you interfering in the first place are either that she should have begun from her own view and then used the evidence as a corrective, essentially, and alternatively, that even if she did that, she wasn't sufficiently careful in her approach to the consumer evidence. In other words, the reasonable proposition which we accept applies to all evidence in trademark cases. Now, my lords, I'm going to deal with trademark and passing off, may I, in order to ensure that I don't miss anything and to keep the woods clear for the trees. Just to quickly set that in the context of the submissions I'm going to make on copyright, very briefly. Partly, of course, my lords, because you will understand from what I've just said in answer to you, my lord, that we do say that the way that the judgment is structured, aspects of her findings find themselves in different parts, even though they are understood to be of overarching relevance in different areas. So, just briefly to touch on passing off. There was a point, my lords, at which it seemed that that distinction might have been important if my learned friend had been running the extreme case, because at that stage it might have been necessary to delve into the differences between passing off and trademark law. But given that my learned friend is not advancing that extreme case, I agree with what my Lord Justice Arnold was saying yesterday, and the court doesn't really need to trouble itself with the difference between the two because of the way it was dealt with. It is, however, important for your lordships to look at my lady's judgment on passing off, because, as I say, you can see there that she is cross-referring to her understanding, which she had given in the context of trademarks, and that, in some degree, helps you to understand what her thinking was in that context, even though she's talking about passing off.
I'm interested that you put it that way, and it prompts a question from me, which perhaps I should have asked Mr. Birss as well. But does it lead to this conclusion that in this court we could simply focus on the passing off judgment? Because it's common ground that the two cases stand or fall together, and therefore, if the judgment is unassailable on passing off, which is your submission, then we needn't trouble about the trademark aspect.
My lord, I would accept that that is a perfectly proper way to go about it. The reason why I will talk nonetheless about trademark infringement is to address in part what my Lord Justice Lewison has raised with me, namely, how can we tell exactly what her thinking was, and because part of her thinking is expressed in the context of trademark infringement, that's important. But my Lord will recall that when it came to trademark itself and on appeal, my learned friend, at least in his skeleton argument, raised a number of other issues, so as to detriment, as to unfair advantage, and as to due cause. And I think it would be fair to say, having heard my learned friend yesterday, that the issues on detriment and unfair advantage, which, at least in the skeleton argument, were put on independent bases, now devolve down simply to the question, was my lady justified in finding a link that would then lead to the kind of message that my Lord Justice Lewison was asking me, did she think would arise? Because I think my learned friend described it, at least to me personally, as his bootstrap argument. That's what he relies on now. The separate point that's made in the skeleton argument, is there in fact any evidence, or is indeed the evidence only that of responsive advertising, is not, I understand now, independently pushed. So I'm not going to take time over that. Similarly, and this is a point that my Lord Justice Arnold made yesterday, where does it get him on due cause in circumstances where passing off would be enough? And indeed, although my learned friend made a valiant attempt to explain why he himself considered that there would be due cause, he didn't engage with the issues that are actually raised at the trial, and indeed began to explain why he thought that it would be possible to say that there was due cause to use these individual elements, although that was an issue that the judge had expressly canvassed, and I'm going to touch upon that partly because it answers my Lord's earlier question about how the link automatically arises. But also at no point did he touch upon the real question, which is the copying, and whether or not you could have due cause to have copied somebody's sign. So again, those can be dealt with very quickly.
Can I just
Yes.
ask you one, just put something in your mind at any rate?
Yes.
I understand where you're going, I get that, but the bit of this that's troubling me a little
Yes.
is I can understand how one could conclude that the Tesco were doing creates a link.
Yes.
But it's a different thing to say that it's a link which inevitably, or to some very high standard, leads to a price match. I can also understand that it might be possible that some people might think there's a price match, perhaps. But as I understand it, the finding is that the link creates the idea of a price match. And that's why the passing off is the same as the trademark infringement. But if that's not right, in other words, if there is a link but not necessarily a price match to the same degree, then I'm not sure the trademark and the passing off are the same.
I understand the distinction that you're making, although I would also say that my understanding is that your primary concern is actually the same one that my Lord Justice Lewison has expressed to me. Namely, okay, they see that the signs are similar, okay, they understand that there's a link to Lidl, but then there's a further step that must be...
I'm sure it is the same, but the reason I'm putting it to you is to do with your way of looking at saying just look at passing off.
Indeed,
Just to pick up my lord's point,
yes.
if there is a link, but the link does not convey the price match message, what is the misrepresentation for the purposes of passing off?
No, I understand that, my lord. It is our case that as soon as one makes the link to Lidl...
No, I follow. So it all depends on the sign conveying the price match message.
Conveying the value message. One of the points I want to pick up on, my lord, is this idea that we're focusing on a particular formal price match. That was neither the pleaded case nor the case that was understood by the judge to be an issue. It manifests itself in the idea of the price match in the sense that an ordinary consumer would understand it, that there is some value comparison occurring between the two supermarkets. What I'm shying away from is the suggestion that they need to understand that there is a formal price match happening of the kind that is required by the legislation, and which was, of course, actually being done in respect of Aldi. And part of the point that we say on unfairness in this case is that they obtained all of the benefits without any of the obligations that were required to do so in a formal sense. But, my lords, I fully understand, I think, I hope, the concerns that you have both raised. And in my submission, it is the material that you have not yet been taken to, and which finds itself encapsulated in paragraph 99 of the judge's judgment, right, that explains all and, to paraphrase, excuses all. My lords, I was very briefly going to, as I foreshadowed, talk about copyright, not to get into the detail, but just so that it contextualises the trademark and infringement. As I say, what the appellant there is issuing, we say, comes down to an issue of framing, ultimately. Not framing in the sense that my learned friend uses it, but rather framing in the sense of asking yourself what were the creative choices that were made. Because the appellant is alleging that the intellectual effort involved in the work is so simple as to warrant neither protection nor a finding that what has been copied amounts to a substantial part. And they are saying that the judge erred in her assessment by incorporating into her framework matters that were not properly to be considered as part of the creative effort of the work in question. Now, we say again that that submission does not survive review of the judgment, and that once the court appreciates that the judge well understood the elements that could be considered to be part of the creative efforts that led to the work in issue, there's no further basis for challenging her conclusion that it was sufficient to warrant protection. It really is a case of there being no error of principle, a value judgment by the court below that should not be touched. One of the cases that the appellants rely upon or point to is, of course, Designers Guild. My lords will understand me when I say that that is an apposite case to this one, because there the House of Lords indicated that what the appellant really wished to do was to challenge the finding of copying, knew it was on a hiding to nothing in doing so, and therefore sought to obtain an equivalent finding by reference to the issue of substantiality, and it is the same gambit that is at play in this particular appeal. My lords, can I turn to the first issue on the trademark and passing off appeals? And I've headed it, No Reasonably Circumspect Consumer. Can I ask you to turn up Tesco's grounds of appeal? They can be found in Core Bundle B and at tab 24, page 487. in our submission, the heart of their trademark appeal is to be found in paragraph 2. Here it said, no reasonably circumspect and well-informed consumer would conclude price matching with Lidl was occurring, and 2 reasons are given for that proposition. The first is that there was no express mention of price matching, and the second is that there was no mention of Lidl on the sign. Now those points, my lords, are expanded upon in the skeleton argument, which you find behind the following tab, tab 25, to page 498. There, at paragraph 16, the 2 points that were in paragraph 2 of the grounds of appeal have become 3. The first subparagraph of 16 repeats the 2 initial points that we saw in the grounds of appeal. The second subparagraph suggests that the CCP signs in fact conveyed a particular message, namely that the goods so labelled was subject to the well-known club card scheme, which offered special prices. And the third point is that the similarity between the signs and the mark with text lay in the yellow circle and blue background, which were features said to lack real distinctive character, and the average well-informed consumer would not be surprised to see them in promotional material from other supermarkets. And the reason this is where they start is because they want to convey the impression that absent evidence, it was a remarkable conclusion to have reached. The first issue, therefore, that we draw attention to is that the argument in their skeleton, as you have just seen, does not align with their grounds of appeal in a significant respect. That third point made in the skeleton, the allegation that the common features lacked real distinctive character and were in effect commonplace in promotional material, forms no part of the grounds of appeal on trademark passing off. At the same time, it was an issue that was effectively addressed by the judge when she gave consideration to the question of whether the wordless mark had distinctive character. Now, the significance of the wordless mark is that, save for the presence of the red rim around the central yellow circle, it possessed precisely those features that were in common between the CCP signs and the mark with text. So in our submission, it's a useful place to start in looking at the judge's assessment of that question. Let me preface my specific remarks by a general observation, one I've slightly already foreshadowed. But the learned judge has endeavoured to be extremely detailed in her analysis, but not repeat herself unnecessarily, and that's had 2 consequences. The first, as I have already said, is that she has dealt at greater length with matters of particular contention between the parties, and the quantity of paragraphs is no indication of their significance to the ultimate conclusion. I mention this in part, my lords, because it's in their skeleton that you can assess how she's approached things by the very structure of the judgment. We said only shows that this was an issue where there was a particular debate at trial. The second consequence, we say, perhaps unsurprisingly, given this dispute, where there were a number of topics that had subsidiary issues that applied across them, is that you will find some reasoning in one part that is cross-referred to elsewhere. Now, when it came to the distinctiveness of the wordless mark, one of the pieces of evidence which the judge considered and which had been the subject of an interim dispute as to admissibility was a survey carried out by YouGov. And my lords may recall that we mentioned the significance of that fact, that it had been the subject of interim dispute, because in that context there had been detailed consideration of my lord's judgment in Interflora, which has become the subject of, or we thought was going to become the subject of debate on this appeal. Therefore, going into this trial, we say the judge was alive to the issues raised in that judgment, which are issues of caution as to the ability to extrapolate out to the views of the average consumer. She gave permission to admit the survey, and she deals with it in her judgment at paragraph 201 and following, and that can be found, my lords, at page 617 in the bundle. Now, my lords, I don't ask you to read it now, but just to say that at 202 she is summarising the process of the survey, and at 203 the results. But if you turn over to page 618 and paragraph 208, you see her conclusions from this survey summarised, we submit, in the quote from Lidl's expert to be found at the very bottom of 618 and set out at the top of 619. Namely, that the YouGov survey indicated unambiguously that the image shown in the survey, which was the wordless mark, is perceived to be the Lidl brand in the view of the general population. And there was cross-examination on this point, and that's set out below. And from there, the judge turned to consideration of the challenge to the distinctive character made to the wordless mark. That can be found beginning at page 620. She sets out the legal test and then turns to the question of fact. And again, my lords, without wishing to skip over anything that your lordships may wish to read, can I ask you to turn to page 622 and to what is said at paragraphs 220 and 221. I draw your attention to paragraph 220 because I don't want to have to take you back to it when I come to bad faith. But you will note there that the use that is being relied upon predates the application of the wordless mark. But for these purposes, the one that I'm talking about now, it is 221, to which I draw your attention. And she's looking at the impact of the YouGov survey. And we say her first observation in that paragraph is that the mark with text and wordless mark, though simple, are striking and memorable. Her second observation is that the evidence in the form of the YouGov survey establishes that the elements of the wordless mark, I pause here, that is to say, again, the elements in common with the CCP sign, are immediately recognisable as denoting the Lidl brand. If the court reads on, towards the end of the page, the judge observes that members of the Vox Populi provided unprompted commentary, identifying that in their view the CCP signs were literally the Lidl logo, the Lidl rip-off, the @LidlGB colouring and logo pattern, and that they were uncannily similar to the Lidl logo, in my mind persuasive evidence of the way in which the mark with text is perceived, in common with my own impression. So here we see, my lords, one example of where we say the judge is expressly acknowledging that she had her own impression, and that own impression was one of similarity, which the evidence is simply serving to confirm. If you go on over the page,
And this is this right that looking at 211, this is a case of acquired distinctiveness?
no, my lords, this is a question of whether or not the mark had distinctive character. And in that context, obviously, one could rely on either its inherent distinctiveness or acquired distinctiveness. Now, the YouGov survey was testing matters after it had been used and therefore cannot distinguish between the inherent and the acquired distinctiveness. What we submit, however, is that the judge herself has said that the mark is striking and memorable, and that can only be a reference to inherent characteristics.
Well, I just wondered, her phrasing is that the YouGov survey provides strong evidence that the wordless mark has acquired.
Indeed. Well, both factors are relevant.
Yeah.
She's acknowledging what we would say is inherent distinctiveness, and then she acknowledges that, leave that aside, even if that weren't right, there is acquired distinctiveness. And again, my lords, this I'm drawing to your attention partly because I'm going to come back to it on bad faith, because you will see, we say, that it has always been said to have strong inherent distinctive character, and by that I mean the wordless mark.
And the wordless mark includes the red circle.
It does indeed. It does indeed.
And
Now,
distinctiveness is acquired not through use of the wordless mark itself, but through use of the mark with text.
absolutely, my lord. Absolutely. And of course, as we know, that's the big issue on bad faith, because as my lord made clear, that raises the inference that there may be a defensive mark in operation here, and so that needs to be explained. But here, my lady is not dealing with that question of bad faith. She is dealing with the question of what do the elements of the wordless mark convey to the public, and whether as a matter of inherent or of acquired distinctiveness. Her factual conclusion, not challenged on appeal, is that they immediately speak of the word of Lidl. And if you were in 221, but only still on page 622, you were on the words in common with my impression. You see, she then goes on. The background, so namely the element of the wordless mark, plainly perceived as having considerable distinctive significance. She gives another quote, when I see the Tesco advert with all the blue and yellow, all I think of is Lidl. The link that the Lidl Vox Populi have made between Lidl and Tesco is premised upon the elements to be found in the wordless mark. My lords will recall that's my submission to you, and the judge is accepting it. Even to the extent that consumers were not disabused of that link by reason of the presence of the club card prices text. And again, my lords, one of the points that I'm trying to make in my submissions to you is that there were particular arguments put by Tesco at trial. They said not just that the CCP sign and mark with text were of low similarity, but even that they were dissimilar. And part of their argument for that was that the presence of the word club card or Tesco served so powerfully to draw the attention of the consumer that they were rightly to be treated as dissimilar. And here, therefore, one of the issues that the judge is expressly addressing herself to is the significance of the presence of the club card prices text. And she goes on to say, the strong inference is that the wordless mark, certainly as it is used on signage, shines through the mark with text such that the average consumer recognises it as being distinctive. Now, sorry, one moment. If we leave aside for the moment, therefore, these findings, we say, are not challenged on appeal. They inform her understanding of what is going on in the minds of consumers. But I ask you just for a moment to leave aside the question of whether or not that third point in paragraph 16 of my learned friend's skeleton is open to them on appeal. What we see in the passages here is that the evidence in the YouGov survey is being taken to show the distinctiveness of the elements common between the mark with text and CCP signs, and that it is evidence that is confirmatory of something that the judge already views as being her own impression. And we submit that that fatally undermines one of the three pillars of their position at paragraph 16 of their skeleton argument. And if we then go on to look at 222, the judge is addressing further support for the proposition that the wordless mark shines through the mark with text, such that the average consumer recognises it as being distinctive of Lidl. And the reason I draw your attention to this is that here she is referring to the further support to be found in the internal observations of people at Tesco, such as their head of marketing communications. And in the middle of the paragraph, where the judge gives particular consideration to the question of whether or not she's entitled to extrapolate out from the particular observations of one person to the perception of the average consumer, and as she explains, I consider it is reasonable to assume that Tesco had a good understanding of the nature of the market, the characteristics of the average consumer, and other matters affecting how the average consumer would react to the use of the CCP signs. I consider the internal reservations expressed by Tesco and its consultants to raise the inference that Tesco was well aware of the scope for consumers to perceive the wordless mark to denote Lidl's brands, even with the words club card prices written across it. In other words, they recognise that the wordless mark has a distinctiveness which is separate from and unaffected by the addition of the distinctive word, also distinctive word Lidl, or indeed the distinctive word club cards prices. So, my Lord Justice Arnold yesterday asked my learned friend about when one could extrapolate out, and whether it was possible at all. The answer quite rightly came back, well, it can be done, but you have to give thought to whether or not you have a basis for doing so. Unsurprisingly, a judge who had been asked to consider the reasoning in Interflora, which is all about the importance of doing so, has directed her attention to that very question. and it has appeared here in relation to evidential matters, which of course my lords know is also relied upon elsewhere, but we say is plainly reasoning that ports across to the question of whether or not it can be used in the context of infringement under 10.3. In other words, the sin she is accused of is not one she is guilty of. It's also, we submit, relevant to note her observations in paragraph 224, and in particular what she says at the bottom of the page. I'm quoting here from the word however, 4 lines up. However, I reject the suggestion that the wordless mark is banal, trite, or commonly used background. None of Lidl's competitors uses a similar mark to denote their businesses or brands, although there is evidence of yellow circles being frequently utilised as a means of indicating value. I'm here concerned with the very specific combination of features which makes up the Lidl logo, not with the individual features taken separately. And the reason I draw your attention to that, my lords, is that yesterday my learned friend, Mr. Birss, was boldly submitting, we say, without evidence and contrary to the finding of the judge, these were things that they could use with due cause because banal, trite, commonplace. And my learned friend, Mr. Cuddigan, today attempts the same thing in the context of copyright in circumstances where the judge has held these elements are not so. Now,
She's including the thin red ring.
she is, of course, my lord, because she's talking about the wordless mark. But you will have seen, and I've drawn attention to, the way that she herself has expressly connected the CCP sign elements to the wordless mark elements. And we say, therefore, that conditions her comments. Now, that's one part of the picture. The next part is the question of low attention media. Now, what we submit is that there are circumstances of low attentiveness, even for the average consumer who is ordinarily circumspect. And that's a point that's made by the judge in her summary of the law at paragraph 73, subparagraph 9, by reference to Enterprise and Europcar and Julius Summer. The point that I understood my Lord Justice Arnold to make Enterprise was that it depends on the goods, and a similar point is made by Mrs Justice Kitchen as he was then in Summon. But here, what the judge has correctly done is to ask herself a question about the circumstances in which the average consumer is encountering the signs, of which it must be admitted and accepted that there are a variety. Can I draw your lordship's attention to a few paragraphs from the judgment? Yes.
Just before we get on to that, excuse me, I've got a frog in my throat. One of the features that's noticeable about the judgment, and this is not a criticism, I don't think, for the reason I'll come to in a second, is that one doesn't find a distinct, at least if it is there, I haven't found it, a distinct section of the judgment in which the judge identifies who the average consumer is and their level of attention. And as I take it, that was because it was always common ground, and that is suggested to me by what she says at paragraph 79, where, this is page 583, where she says, in this case, the average supermarket shopper who will be paying no more than the average degree of attention. And the inference I'm drawing is that that was common ground.
That's quite right.
Correct?
That's quite right, my lord. And I would say perhaps unsurprisingly. That isn't, however, to say that there wasn't debate about the level of the environment, the circumstances in which that average consumer would be being asked to appreciate what was going on. And it's those issues that I just wanted to draw your lordship's attention to now. And as I say, the first one was at paragraph 92 sub 4. And the reason I'm doing this is because there was considerable evidence from Tesco's own research that part of the analysis of how these signs worked had to take into account the fact that they were operating in what was described as low attention environments. And that's why they were so careful to look at how quickly the message of the sign was being appreciated, because they knew that it would be caught, as it were, as you were pushing down an aisle, as you were on a bus going past an advert and so on and so forth. And at 92.4, she records two of Tesco's internal people, Mr. Meager, I hope I pronounced that correctly, and Miss Webb, and their internal concerns about the similarity to the Lidl signs. And the response to Mr. Meager, who was of the Insight team, where Miss Webb said, do we really have to stick with this sign, even though people are saying that it looks like the Lidl sign? Paraphrase there, obviously. His response, he observes that whilst the CCP sign may be non-negotiable, as my lords know, never found out why that was non-negotiable, nevertheless, we continue to highlight customer misattribution and risk, especially in the low attention media. Now, we do submit that where Tesco themselves are aware that one of the contexts in which their sign is going to be accounted is low attention media, it is right that the court itself should pay attention to that question. It cannot be dismissed because it is exactly the environment in which these signs are intended to operate. Can I then ask you to turn to 104? Now we're in the context of the H&P evidence, and you will recall this was the out-of-home media that was being looked at. And indeed, the reason that I'm drawing your attention to this is precisely because the out-of-home media, as we will see when we look at it, it was one of those low-attention environments, and the judge is acknowledging that at the end of the paragraph. The next, if I may, is 105. Here she is going into the detail because H&P, again, my lords, someone that Tesco understood to be offering them insight into the perceptions of consumers, obviously not the legal construct of the average consumer, but we say portable reviewing time. They were trying to explain what the problem was. Well, the average viewing time is 2 seconds, they said. So they understand, Tesco understand the context in which these signs are being appreciated, and that is being taken into account. 135.
So just to pause a moment on 105.
Yes, ma'am.
Is the judge there making a finding of confusion? Thinking that Tesco advertisement is in fact for Lidl or vice versa? Is that what she's saying there?
I understand that she saw the evidence of H&P to show that there were confused customers, confused in the tend-to origin confusion sense.
Right.
But
Because
she doesn't.
she makes a very clear finding that in store or on the Tesco website there is virtually no possibility of confusion.
Indeed. And the reason why this is relevant, my lord, is because, as we know from Intel, if one of the issues that you're trying to determine is whether or not the signs are sufficiently similar to create a link, the fact that you consider that there's confusion, or indeed that there is evidence of confusion, is going to help you to answer that question. It isn't that she is thinking to herself, I need to find confusion of the kind that one has found in 10.2, or that having found that kind of confusion, 10.3 follows. She's addressing that specific debate that was happening at trial, in which one side said, they're dissimilar. You won't even think of Lidl. And she's answering that by saying, well, if that's right, and this is one of the ways in which we say, even absent a survey or anything else, if the proposition is absolute, no one would do this, then it's perfectly legitimate even to look at small numbers who are doing it, because one side is saying there are no circumstances in which this would arise. Well, there are. Now, of course, one has to be careful about that, because ultimately that's not the final question. The final question is about that average consumer. So, but the evidence can still be probative of that question. And so that's why we say the 8% figure, whilst itself not leading to the final conclusion, is plainly relevant in our submission, or probative at least, of some of the contentions between the parties. My lords, I am going to come to H&P, but can I just finish this particular topic? 135 was my next reference. And here we are in the internal warning signs. And again, we are referencing, perhaps it might be best understood to be a repeat of the point point we've already looked at, namely that they were aware that there was low attention media and that might explain why confusion of the 10-2 kind was arising. Then 142, my lords, I've only got two more references on this point. 142 is one of them. And it's the fourth point in that paragraph. The judge is aware that there are different levels of attention. And the final reference on this particular topic is at 188. And it's, I guess it might be called a slightly shrewish point, but it is this. Tesco, as the judge saw, were consulting with numerous external consultants as to the power of the signage. One of the consultants they consulted with, Mike Follett at Lumen, he's the man that said, warning, this looks like the Lidl sign. He is an attention specialist. That's one point, my lords. The second point that I want to give you as context is the question of the degree to which there was conscious appreciation of the signs. And for that purpose, could I ask you to turn up the supplemental bundle and page 355, which is in supplemental bundle B.
B.
B, my lord, yes. 355. You've been asked to look at it before, so I can do it very quickly, I hope. It's the source PowerPoint. And it's a page you've been asked to look at, but perhaps, my lord, I could just draw your attention. This is the page you were shown in which, or one of the pages you were shown in which the consumer reaction to those 4 test subjects was being considered. And the particular issue here is, are you noticing a difference at all? And if so, different from normal? And it's the observation on the right-hand side from the experts that the conclusions aren't surprising. They tally with what we've seen across previous research. Shelf edge labels are digested more subconsciously, and it's unlikely that consumers would call them out. And of course, my lords, that's got a number of relevances. But one of them is the question of whether or not you're going to get people realising that they've made the link of the kind that they've made in a way that causes them to stop and communicate with us such that we'd have it. But it does also, I submit, reinforce the point about the low attentiveness of the media and the significance of the similarities. But here also, at page 359, is a point that I will rely upon answering, I think, the questions that our Lords, Lord Justice Lewison and Birss have been putting to me, or at least beginning to answer the question. This you've definitely been shown, because this is the page in which they are discussing the fact that there were responses. And can I just check, we discovered in our electronic version that it didn't contain both the Lidl and the Aldi price match image. I don't know whether my Lord Justice Birss has both.
I've got both on the paper.
The hard copies were fine, but we were aware that.
I've got both too.
Excellent. And the line I draw to your attention is this. The blue and yellow circle did more than just draw the eye. Consumers were then looking for something different to a normal offer and tried to connect the dots themselves. And my lords can see some of the answers as to the way in which they'd connected the dots. Because they'd seen what we would say, the wordless mark shine through, the wordless mark elements of the mark of text shine through. And the dots that they had connected were to a price comparison with Lidl. Now,
While we're here,
Yeah.
can you elucidate the mystery as to the percentages? Because one of my lords pointed out yesterday that every page of this presentation states bottom left that N is 200 per label.
yes,
And so one would think, therefore, that the percentages are always being expressed on the same basis.
yes.
And yet Mr. Purvis told us that that was wrong.
Well, I think my lord sorry, Mr. Purvis is right in the raw sense that the percentages reflect those that have given a particular answer. You don't need to get into it for this reason, my lord, because there was extensive expert evidence on this question at trial. And indeed, when we come to look at it in the judgment, expert evidence only from my side. My learned friend's side did not offer any expert evidence at all. My learned friend, Mr. Cuddigan, tried to get helpful answers in cross-examination. The degree to which he achieved that, we say, is debatable. But the gist of the debate was, can I look at these numbers and draw from them some form of statistically significant result? Tesco had said yes. And we said that's not right. And part of the error we said that occurred was one that my Lord Justice Arnold drew to the court's attention yesterday. They had separated out option 3 and option 4 rather than combining them, even though option 3 contains what we say was the complainable sign. We said if you did it properly, in fact, there was a statistically significant level of confusion here. But we never said that you could do it properly because of the limitations of the way in which the survey had been done. The most important limitation being that the survey participants had been expressly primed to think of Tesco and of Clubcard. And the way in which they've been primed is they've been asked before they went into this, are you a Tesco shopper? And more specifically, are you a Clubcard shopper? And in the expert evidence, our expert was very clear. Again, this is going to my idea, where you've got an extraordinary negative statement. The presence of even a small answers that contradict it is significant. She was saying, what's surprising here, given the level of priming for Tesco and for Clubcard, is that there's any mention of Lidl at all. And my lords can see immediately that that goes to the submission that was put at the front and centre of Tesco's argument at trial, that these signs were dissimilar, that no link would arise because you were in a Tesco environment and the word Clubcard was across it. Quite rightly, the judge said, I can't draw any conclusions as to the numbers of the population, but I can see that there is force in what the expert on these surveys is telling me, which is that it is notable that there are any of these kinds of answers. And in my submission, the fact that the source has chosen to draw it to Tesco's attention reinforces that. So, my lords, just now to go, please, to back. So if you could put that bundle away for the moment. And go back to the judgment, which hopefully you will find behind tab 25. No, I apologise. Behind tab 28 in core bundle B. And if I could ask you to turn to page 654. And you may be asking yourself, why am I in the copyright section when I'm talking about trademarks? But this is grist to my submission to you that you have to look at the whole judgment to understand all the material that the judge had before her. What is being discussed at 3084 is the story of copying. Can I just pause here to say, my learned friend came to court with an explanation for how he got to his sign. It was held to be incorrect and immaterial. The idea that we are now supposed to engage with some new self-invented version of how we got to this sign, we submit, is simply not open to him. But here is the story that emerged from the disclosure that we dragged out of Tesco. And if you look at 3084, she is discussing the instructions that were being given to Wolf Ollins. And towards the bottom of that paragraph, she is explaining that she infers the exercise of looking at how to convey value, which was the task in coming up with the CCP signs, with reference to competitor branding, reflected express instructions given to Wolf-Olins by Tesco. Indeed, whilst denying any intention on the part of Tesco to capitalise on inferences drawn from looking at competitors. That's what they were instructed to look for. Miss McKettrick herself confirmed that where the UK grocery market uses a finite number of colours to indicate value in different ways, it's prudent to understand what is really cutting through in terms of helping customers find the best value by looking at the competition. If you then turn over to 308 9, so Roman 9, we have the briefing that was given to Wolf-Olins in 2019. My Lords may have grasped it was accompanied by what was called an insight research document, which showed what they had discovered so far. And halfway down we see this. Amongst other things, this involved instructing Wolf-Olins to look at what Tesco's competitors were doing and to compare Tesco and competitors. Accepted by Mr Threadkill as an exercise that would inform the design approach, together with revisiting work previously done. An objective of the analysis of competitor advertising was to identify implicit associations. The briefing explained the concentration on the wits, and just pause here, these were the category that Tesco identified.
The fictional family.
Exactly so, and part of the point that we did make to the judge and we make to you now is nobody in this room is the Wicks, and that they were extremely price conscious. And that was a big factor for them in their shopping habits. And indeed, Tesco had warned their designers, you're not the Wicks. Find out what the Wicks are worried about. And that was partly what they went to investigate. And it goes on, they constitute our largest share losses as they switched to Aldi, Lidl, and more recently, Asda. And so the project then proceeded on the basis of asking what implicit associations with value there are. Mm-hmm. Now, that then brings us, my lords, back to paragraph 16 of Tesco's skeleton. Which is page 498, my lords. The first point that was made is that there was no reference to Lidl by name, and we submit that loses all significance once one appreciates that the wordless mark elements themselves were striking, highly distinctive of Lidl. The suggestion that the common features lack any real distinctive character and were commonplace, expressly contradicted by the evidence, but also by the judge's own impression. The presence of the word club card, well, that's already been addressed in the context of the passages we've just looked at. I pointed to paragraph 221, which was the discussion of distinctiveness which dealt with the club card. But if my lords turn to paragraph 195 of the judgment, and this may pick up on a point that my Lord Justice Lewison has reminded me of. Here she's explaining, I simply observe, we are now in the context of the judgment where she's asking if she'd have come to a different conclusion on infringement of the wordless mark as opposed to the mark with text. And obviously, the reason I'm drawing your attention to it here is because she's expressing her reasoning. There's plainly similarity between the background to the CCP signs and the wordless mark. I do not consider that the presence of the additional red ring on the wordless mark affects that conclusion. Her personal consideration, not an evidential one. Whilst the word club card is distinctive, I disagree with Tesco that it precludes any perception of similarity in the mind of the average consumer. Indeed, I note that Tesco accepts the absence of the word Lidl on the wordless mark renders it more similar to the CCP sign. We say that reinforces our general submission that the judgment's reasoning needs to be looked at as a whole for the judge's conclusions to be fully appreciated. The final point that they make in paragraph 16 concerns the significance of the absence of the reference to price matching. And here we want to make 3 points. first is that one needs to appreciate the context of the CCP prices campaign. And I have taken you to the passages in the judgment on copyright that set out the process that they were engaging in trying to come up with the new sign. They were looking to convey the perception of value. They expressly instructed their designers to look at implicit associations of value to be found in competitors, and it is therefore no surprise that they copied what we will say was a very clear indication of value. Now, they were so concerned in particular about Aldi and Lidl, who, as of course my lords will know, were referred to as the German discounters because of their reputation for low prices, discounted prices. But the quickest way to appreciate the power of that reputation is to turn to Tesco's own research. That is to be found in Supplemental Bundle A. Yes, my
I
lord.
have a slight concern because I'm just looking at the way your case is pleaded.
Yes.
What you say in paragraph 22b of the re-amended particulars, page 18
Yes.
of our bundle, is that Tesco's use of a sign serves to suggest that the prices of those goods that are offered by Tesco for sale under or in connection with the sign are offered at the same prices or lower prices than can be obtained for the same or equivalent goods in Lidl, or are otherwise price matched with Lidl, contrary to fact.
Yes.
You're not alleging that they're making general claims that you get good value at Tesco. They're making a very specific claim
Of relative value.
about the comparison
Yes.
between Tesco's prices and Lidl's.
Absolutely, I don't shy away from that. But you will note that in that passage it is price match in inverted commas.
Yes, I do.
They don't understand that a specific price match is going on. They understand that overall the value that they are now obtaining from Tesco is equivalent to the value that they're going to be obtaining from Lidl. And indeed, you see the same contrast being made in the section that deals with passing off at 28, where
Yeah.
price match is offered as an option, an alternative option to the kind of express price matching, and again is in inverted commas. And we say that that is how the judge understood it, and when we look at unfair advantage, you'll see that's how she expresses it. And certainly it was the basis on which it was put. My learned friend Mr. Cuddigan tried to address it by suggesting that in fact you could see that they weren't worse value. That was a thing that he failed on the evidence. My client remains better value, we say. But at any rate, the impression that was to be given was that you could safely shop at Tesco knowing that you wouldn't necessarily get a better price at Lidl. And indeed, some of the Vox Pop are saying exactly that. Thank goodness I don't need to trek out of town to Lidl. I can get the same value at Tesco. They don't put it in terms of specific price match, but that's what they are understanding. And I
It's
want to...
different from just value, though, isn't it?
So, what, a price match? Well, it's different in this sense. That value could encompass all manner of issues, including the possibility that you're getting a better product, albeit at a more expensive price, but still good value for the product that you're getting. But, as we will see, what was understood was that you were going to get a better price. In other words, that the price was better than the one that was at Tesco.
Why does it have to be a better price than Lidl? Surely the idea of conveying value is simply that it's value. It's a lower price than you might have thought. That's value.
Yeah, well, indeed.
It doesn't have to involve Lidl.
It doesn't
It
have to
doesn't have
involve
to involve the price.
It doesn't have to
In
involve.
other words, you could convey. I mean, what you've shown us, Mr. Randolph, was that they were seeking to convey the idea of value.
Yeah.
And I understand that.
Mm.
What I'm questioning is dare I say the link that you draw from that to saying that you're trying to convey a price match.
Yeah.
Because that doesn't necessarily follow, does it?
Well, it doesn't
Even in the inverted commas price match sense.
Well, it doesn't necessarily follow. I must accept that. But in the context where Lidl's reputation is entirely about low prices, value in that sense, once one has appreciated that and thinks of Lidl, one can only understand it in our submission by reference to it being understood as better prices.
And that's exactly the point I'm putting to you. Is that I can understand that you convey the idea of Lidl as a value proposition.
Yeah.
That doesn't mean that you're price matching Lidl.
Well,
that just means that you're getting the idea of, oh, it's cheaper. That's good. That's value.
Cheaper than Tesco.
Yes.
That is a price match, my lord.
No. Cheaper than Tesco is cheaper than Tesco. This is a cheaper Tesco price. It's value.
Yes, indeed, my lord. It's part of the point, right? That a club card price is offering you a special price, one that the message of a link to Lidl is telling you is comparable to the Lidl prices.
No, it's just cheaper than the Tesco price you would have otherwise expected.
Well,
why does it have to be comparable to Lidl? That's the point I'm putting to
Well,
you.
the reason why it has to be comparable to Lidl is because you've used the Lidl logo. That's the comparison you're making.
Okay, well, that's what I'm putting is that's the assumption you're making when you jump from the idea of conveying value to the idea of conveying a price match with Lidl.
Absolutely, my lord. And the process that I'm going through is, first of all, I'm showing you that there was overwhelming reputation for low prices at Lidl. And then I'm showing you that the judge understood that therefore indicated by its presence that there was a comparison of price being done with Lidl. And she found in the evidence confirmation that that's what was being understood, and it concurred with her own view.
Okay.
But what I'm distinguishing is the idea that what she had to establish is that people were making a conscious thought, here is an express price match with all of the elements that are involved in that. That was not our pleading. Our pleading was that they understood that there was some comparison of price being made with my client, because my client is known as a discounter. Let me proceed, my lord, because my submission is that it will become clear once one sees what Tesco themselves understood this reference would indicate. And I was asking you to go, if I could, to supplemental bundle A and to tab 20.
Tab 20.
Yes, please. This is a document to which I've already referred. It was the synthesis of insight. So the research that had been done by Tesco up until this point was provided to Wolf Ollins as part of their preparation for research.
Now, this is part of the brief to Wolf Ollins.
Correct, or at least as we understand it. I mean, one of the problems that we faced is never heard from Wolf Ollins.
Yeah.
We sought disclosure on the basis that they were documents that Tesco were controlled. We didn't get any. Now, my learned friend says you can speculate about what happened to Wolf Ollins. We say you can't. But it did emerge that this had been provided to Wolf Ollins from Mr. Threadkell's evidence. And the first page that you see at 299 is setting out what they understand to be the issue that they have to tackle. And it is about winning back the Whigs and about the question of value in the context of everyday low prices and promotions. So these are, in terms of the value, it is about the lowness of the price. And on the right-hand side, you have YouGov data that is assessing long-term view on value perceptions. And in the middle, you have two lines. The red line is Tesco's value perception. The yellow line is the big three. So that's
Sainsbury's, Asda, Morrison's.
exactly.
What are they?
Yes, not Waitrose.
Out of interest, what is it?
Sorry?
What is the big three?
As my lord just said, so I understand it to be Sainsbury's, Morrison's, and Asda, outside of Tesco. If I'm wrong about that, I'll be correct. But that's my understanding. Definitely not Waitrose. But what you also see, my lords, although Tesco's value perception is comparable to those other big three, there are two supermarkets whose value perception is so great it is off the chart. That is Aldi and my client Lidl. They
Yeah,
then
I see Aldi and Lidl combined 45 plus.
That's quite right. Now, what we then go on to see is that they have tested a huge amount of value communications.
What does a matter of interest? What does the vertical axis represent? What are the numbers?
I cannot answer that question. Whatever scale it is the point I'm making is that Aldi and Lidl are off the charts relative to it. It's some measure, presumably responses to the YouGov survey of what good value what good prices do you think? We must assume it's something to do with value because of the title. but it's being presented in the context of Tesco understanding where the problem arises with Aldi and Lidl. And they explain that they've done a huge amount of testing. And they go on to set out what they have discovered from that testing. The judge discusses this at 308.10 for your notes. You don't need to go to it. At 305, having looked at 209, the next page to look at, we say, is 305. They're explaining that they need to continue to work harder to convince consumers of our great value compared to some of our competitors. And what's happened here is that they've got 4 adverts. You see them in the middle of the page. The one on the left is a Tesco branded advert. It's got the words Tesco on the left-hand side. It's got yellow price bubbles. That advert has then been manipulated 3 times. Only 2 changes have been made. Tesco's been taken out and the competitor brand has been put in. And the price bubbles have been changed in shape and colour to reflect those brands, but not the goods or the prices. The consequence is set out below. Those seeing the Tesco branded ad instinctively rated the price metrics, my lord was concerned, what is the metric? The price metric, noticeably lower than the competition. Simply putting my client's brand into an advert and making no other changes was enough to make it look as if, to consumers, the prices were better.
Say that again.
Simply putting my client's brand into an advert was enough to make the prices look better. You see, bottom left circle, minus 17%, better prices than I would expect. The prices haven't changed. The brand has changed.
Which are these? But these circles.
Yeah.
What do they relate to?
They relate to the outcome of the research they've done.
Yes. I get that. But what does minus 17% relate to the perception of somebody looking at Aldi or Tesco? Or?
It's Tesco. It's what happens if you put Tesco in. If you put Tesco in, people think the prices are worse. 17% worse. So
The text on the left-hand side helps to understand what's going on.
Sorry, you're quite right. In the abstract, they do fine, but pop the Tesco logo back on, and people instinctively rate us lower.
I.e. we're more expensive.
Yes.
Yeah, that's what I think. That's probably what
Sorry.
I'm struggling.
Yeah. In other words, so powerful is my client's brand value,
Right.
but merely by its presence.
And the minus numbers in front of the percentages mean what?
That's the change in the value once you put the Tesco logo back in.
It's not necessarily you. You keep saying your client, and I do understand, Mr. Brandon, that your client is Lidl, and Lidl is one of the 4.
Yeah.
But there's nothing on here that shows me that these numbers or the comments are anything to do with the comparison between the Tesco and the Lidl, rather than say the Tesco and the Aldi, or the Tesco and the Asda.
Sure, my lord. And you won't be surprised to discover, if you look in the bottom left-hand corner, that there's a source given for this research. And we asked for it, and we were denied it.
Okay.
So
you're telling me as if you know what this is. Now you're telling me actually you don't know what it is.
no, I do know what it is, my lord.
All right.
I do know what it is. What it is that Tesco's value perception is worse than these 3 supermarkets by a noticeable factor. And that by changing to one of those brands, being my client's brand, consumers understood instinctively
Okay.
that the prices were better. And my lord's question to me earlier was, well, how do you make the link? And we say that the link is there. It's written into the DNA of my client's brand. As soon as they see Lidl, as this research is showing, they understand that the prices are better.
Or to
By
use
comparison with
the
Lidl.
language of the document, it's not a level playing field from the beginning.
Indeed. The evidence was overwhelming. It was the entire sum and substance of this project to obtain the benefit of that link and that particular connection. So that when we return to this question in paragraph 16 of whether or not the presence of the words "this is a price match" are preventing you, or meaning that you don't make that link of the kind that we're talking about, price matching in inverted commas, we say that you can see that that was not sufficient to
So what you're saying, I think, is that once Lidl is brought to mind, Tesco is more highly rated on prices than would otherwise be the case. See page 305.
That's right. That's what they understood. That's what they directed their designers to. That's why they said, find out why that is. What are the implicit associations that are leading to that result? Their designers looked, copied, and then we say, lo and behold, the value perception of Tesco changed because they were taking our reputation. In the judgment, my lords.
Does the judge deal with this?
Yes. If we start at 271, do you mean with the specific evidence or with the question of value? Well, let me address both if I can. At paragraph 271, my lord, you have a summary of, in passing off, of the judge's understanding. And we say, consistent with what I've submitted to you, it wasn't that there was a formal price match going on.
No, I just wondered if she dealt with the document you've just shown us.
The answer off the top of my head, my lord, is that it's almost certainly dealt with in the context of the discussion on copying, and I think from memory it's 308.10, which is at page 656. Does my lord see it? That is the synthesis of insight.
Yeah.
But I've been reminded that there's another reference.
So it's the clear message from this that Tesco's competitors, including Lidl, had a significantly better value perception. That's what you're relying on.
That's right. And then there's a reference, I understand, at 589, footnote 9.
Sorry, what was the last paragraph?
The last one is page 589, footnote 9.
Right.
And it's in the context of something I took you to earlier, where it was about average dwell time for ads being only 2 seconds. So it's a different issue.
Yeah.
But, and the judge not only dealt with it in the context of passing off, but obviously also in the context of unfair advantage. And the paragraphs there, which I know my lords will have looked at in some detail, are 176 and 177. I won't take you back to it now. My submission is that it is to this challenge from the discounters, Aldi and Lidl, that Tesco is seeking to respond, and it informs, therefore, the second point of context that is relevant to the understanding of consumers, which is that the CCP signs are appearing in stores. And you were shown these in my learned friend's opening, but can I just very quickly take you to Miss Farrant before the short adjournment? Because although you were taken to parts of Miss Farrant's, so this is supplemental bundle 1A, and it's, sorry. I'm in the wrong bundle, apologies.
This is tab 3.
Quite right. You were taken to various photographs. I don't want to take you to the same ones again. Can I ask you, please, to look at page 61. you've got 3 photographs of the inside of a Tesco store here. And what we submit is that one sees immediately that out of the 2 people who are united in the minds of consumers, they're the German discounters. One is being expressly price matched, but alongside it is the sign that we say would be immediately recognisable as Lidl, and which would be immediately recognised as conveying an issue of value, price specifically. If you turn over from there to page 64, the adverts on the right-hand side are the real world. So the first 2 are there for explanatory purposes, but you can see in the bottom right-hand corner a Tesco advert. You've got 3 price match issues, Aldi price match, low everyday prices and club card prices. They're being presented conceptually in the same context.
So the train of thought is the consumer sees Aldi price match, then simultaneously sees the sign, makes a link with Lidl, and says, oh, well, they must be doing the same with Lidl.
If they're doing it consciously, yes, but I submit to you that some of them will be doing it subconsciously, and that still counts. And what I'm addressing specifically is the proposition, paragraph 16, that it's somehow remarkable that that conclusion could have been reached consciously or subconsciously, given the absence of the words price match. And we say, actually, when you look at the context in which they're being presented, knowing as we do that this is a low attention environment, there is no surprise at all that the judge's own conclusion was that there was 10-3 confusion. And I do say that it's important in this context that the special prices were only available to club card members, so that this was not a general price match being offered. This was one specific to those special customers, and that was part of what we say is the loaded context. We've got identical businesses, identical services, retail of groceries. The customer knows that Lidl competes on price, not on range or quality of goods. If you're absorbing the club card prices message, so if you're conscious of that, it's not going to disabuse you of the idea that there is still price comparison being made with Lidl. You just understand that you're in the special category of people who are entitled to take the benefit of that. And again, really, it's a negative point, if I may put it this way. This idea that is expressed in paragraph 16, that it was a startling idea that the judge would conclude there was a problem here to begin with, until driven there by the evidence, we say just that doesn't bear the weight that it needs to. After lunch, my lord, I'm going to look at what the judge actually did.
Yes, all right. Thank you. 2 o'clock.